Metanomics is brought to you by Remedy Communications and Dusan Writers Metaverse.
And how about looking at user-to-user transactions? I mean, I know that a lot of the Second Life legal community has been involved in trying to understand the advice that they can give their in-world clients in dispute resolution with other other residents, and when it might be possible or appropriate to bring in Linden Lab or whichever world it is, the developer. Do you see? I mean, is there truly novel law to be made here, and different advice you would give to someone who's doing business in a virtual world when they're dealing with counterparties?
To some extent, yes, and to some extent, no. I mean, many of the traditional legal principles that apply to any other web-based site will also apply to virtual worlds. There are a number of areas where, because of the nature of the interaction in virtual worlds, there's ways in which users can interact that you can't interact through just a text-based website, for example. So there can be scenarios where it's different, but many of the common principles apply. And when you're dealing with, whether it's eBay, where you have consumer-to-consumer transactions or consumer-to-business transactions, I think in integrity and doing the right thing really is a big part of it. And when people are cheated, or if there's a legal issue, one of the challenges that have existed so far in virtual worlds is that, despite the fact that many people are devoting a lot of time and resources and generating a fair amount of revenue from these activities in virtual worlds, in many cases there's really not enough money at stake to even file a lawsuit. It just is not. It's cost prohibitive. So many of the situations, we get calls from clients all the time, or potential clients, with issues and problems they've had either with selling virtual goods or buying virtual goods, or people copying their wares. And there are certain things that you can do to help position yourself. So to protect yourself, for example, on the copyright side, if someone is unlawfully copying your goods and trying to sell them, or selling them, or even just distributing them for free and destroying your market, one of the things that we see, unfortunately, is that many times people do not file copyright registrations to protect their works. And in some cases it's hard to file copyrights on everything you do, but one of the big advantages of having a copyright registration filed before there's infringement is that you can get what's called statutory damages, which means you don't have to prove what your actual damages are. You can get by statute certain minimum damages. And for clients that have copyright registrations, they're in a much better position to enforce their rights if people are stealing their goods or otherwise distributing them without authorization. So and that's one example of where people, and it's relatively cheap. It's $45 to file a copyright registration, and in most cases, once we've helped the client do one or two, they can do most of the rest of them themselves. So that's an area where you can really help protect yourself by taking a little bit of steps for prevention that really provide a lot of available remedy on the back end.
We have a comment from one of our viewers, Gentle Heron, saying it's hard to know what's copyrightable in this environment. So, do you have a sense of so if I create a building, is that something I can copyright? If I make clothing, virtual clothing in Second Life, is that copyrightable?
Yeah, generally any original work of authorship is copyrightable. So if you're creating original content, then it generally is going to be at least something you want to consider for copyright protection. And if you're not clear on whether it's protectable or not, that's a good reason to call an attorney who specializes in this area. Where you clearly can't protect things, you can't protect kind of functional aspects through copyright. Copyright protects just the creative side. So to the extent that you have created something that performs some function that type of thing is better protected by patents. And so one of the things, and many people, I mean, it's a very good question, and many people kind of don't really understand where the lines are drawn between the different forms of intellectual property, whether it's copyright, trademarks, patents, and they're not necessarily mutually exclusive. Many times when we work with clients to put together an intellectual property strategy, you're going to use elements of each to protect different parts of the virtual world. And design patents are also relevant as well. Design patents are like copyrights, but again, they're different than the utility patents, which cover the functionality of what your site is doing. The design patent covers kind of more of the ornamental aspects of screen displays, things like that.
So we have a couple questions here now on patents, and so can you patent an island design? Can you identify what would be patentable within virtual worlds? Could you just elaborate on that a little bit?
Sure. So again, patents protect really more the functionality. And you can protect methodology, functionality, kind of user interaction features. Despite some of the recent cases, there's still aspects of patent protection available for novel business methods that are implemented through virtual worlds. So there's various different levels of abstraction at which you want to look at your virtual world and assess where there's patent protection available. The most valuable protection is going to be at the highest level, right? The business method and/or kind of what's the overall functionality. To the extent that you've developed tools or written scripts or code that enable you to do things that maybe are known already, but you're doing it in a way that's cheaper or better or faster, you can also protect things at that lower level. However, those patents are generally less valuable in that people could write the code a different way, and then those patents wouldn't be infringed. But if people replicate functionality and you have kind of functional features of a virtual world protected, regardless of how it's coded, even if people use independent coding, then patents at that level can be would be infringed, and having those patents can be very valuable. We're seeing a number of, without getting specific.
Okay, just if I could clarify one thing, are you saying that if I'm a Second Life resident and I create an object that maybe has some scripting in it, I'm using the Linden provided languages for scripting, I could actually have a patent for that?